Since they are still refusing to give us our constitutionally required referendum, today I am voting in my own little one-man referendum. So I'm voting no, but when we do eventually get our referendum, remember that your vote is your secret. So, there are several court cases pending before the courts demanding that you and every one of us will get to do exactly the same and have your say on Constitutional Amendment number 3 as the Constitution requires. In my previous video, I spoke about the 5 arenas in which the struggle to restore our Constitution must continue. Those 5 arenas are the courts, the streets, our hearts and minds, our communities, and the spiritual realm. Today I want to focus on the first of those 5 arenas, the courts. A lot has happened over the past few weeks. Several different legal cases have now been launched in relation to Constitutional Amendment number 3. Many people have understandably asked, why are there so many different cases? Are they all saying the same thing? And what exactly are these court cases trying to achieve? So in this video, I want to bring you up to speed on where everything stands. The first thing that we need to understand is that there isn't just one court case. There are many different court cases which are attacking Constitutional Amendment number 3 from different angles, focusing on different aspects of the constitutional amendments. So, some focus on the process, how Parliament conducted itself. Some challenge whether members of Parliament acted unlawfully or even criminally. Some insist that the President and Parliament shouldn't benefit from the changes to their term. Some demand that the amendment must go to a referendum. And several ask the Constitutional Court to declare that the constitutional amendments are unconstitutional. These cases aren't competing with one another, they're more complementing one another. They are asking different legal questions about the same constitutional amendment. Let's start with the procedural challenges. So the first set of challenges are cases which concern the process, such as the public consultations. Now, our Constitution doesn't just require Parliament to go through the motions, it requires meaningful public participation. Parliament must facilitate that. And these proceedings argue that that didn't happen. Among other things, they argue that there was an insufficient number of public consultations, just 60 or just over 60 countrywide. When you compare that with the 2013 constitutional process where thousands of public consultations took place, you see how inadequate it was. Then the fact that many citizens who did attend those hearings never got a chance to speak. Many were prevented from speaking, and in many places the meetings descended into intimidation and violence, including of course the well-known case at City Sports Centre where I was attacked, but many other similar cases all across the country where people were attacked and subjected to violence. So those cases are arguing that the Parliament failed to conduct itself in doing the public consultation. Now, there are also legal processes unfolding around the allegations of bribery in the process in Parliament. So complaints have been lodged against at least 3 members of Parliament, Honourable Mureyani, Matangira and Matsunga. And the allegation against those members is that they received Toyota Fortuners and approximately $50,000 each from businessman Wicknell Chivayo after publicly supporting CAA3. And it is a criminal offence for a member of Parliament to receive a gift or reward for promoting a bill before Parliament. So the MP's actions taint the whole process of CAA3 becoming law with criminality. Parliament's own ethics require that those MPs should not have participated in the vote, having received gifts. And there are, of course, allegations that many other MPs also received gifts and bribes for the way that they voted in CAA3. However, the evidence for that is yet to emerge. So these cases center on the MPs, where the evidence from Mr. Chivayo's own public statements, in which he expressly linked the gifts to members' support for constitutional Amendment 3 specifically for the first two, and to Mr. Mnangagwa for the last of the three. And so those ones focus then on the criminality that tainted the process in Parliament. And there are several Constitutional Court cases which are challenging the Constitutional Amendment Act directly. So now, they are all challenging the Act, but they take slightly different approaches. So, for example, the first case which we can mention is that brought by Varunde Mahlupego, and this case deals with some procedural and substantive aspects. So this application was filed by Professor Lovemore Maduku and his legal team, and it's a broad challenge which is raising several different aspects. It argues that Parliament and the President failed to fulfill a number of constitutional obligations during the process amending the Constitution. Among other things, it raises issues concerning that there were amendments which were introduced to the bill after it had already been gazetted. There are questions about whether the constitutional procedures were properly followed, whether the term limit provision protections were respected or breached, and whether a referendum was required. So this case seeks to declare that Parliament and the President failed to fulfill their constitutional obligations and to invalidate the amendment bill. Now, the second case we'll look at is that of Prince Dubego Sibanda, who's represented by Mbizo Muchadehama and Makoni. This application focuses primarily on one issue: the constitutional protection against changing term limits in a way that benefits those who are already in office. So it argues that CAA3 unlawfully allows the President and the current Parliament to benefit from changes to constitutional term limits, contrary to Section 328 of the Constitution. And the relief sought is to have those specific provisions declared unconstitutional. The third case is one filed by Chingua and India. This is an application which was filed by Tendai BT Law. It's brought by two veterans of Zimbabwe's liberation struggle. And this case argues that CAA3 should never have become law, primarily because it ought to have been approved in a referendum. It argues that CAA3 changes important constitutional rights, including the right of Zimbabweans to elect their president directly, and also changes how some senators are selected. And because those changes affect constitutional rights, the applicants argue that Parliament was required to obtain the approval from the people in a referendum before the bill could become law. It also raises arguments concerning the presidential term and protections against incumbents benefiting from the constitutional amendments, particularly those in Section 328. Then the fourth one, which I'll mention, is one filed by Douglas Mwanzora, and this is an application which, similar to the previous one, is focusing on the right to vote and how the amendments affect Section 67 and our political rights, the right to vote, and argues that the changes, because they affect rights in Chapter 4 of the Constitution, ought to have been subjected to a referendum. So yeah, there's an overview of some of the cases that have been filed before the court. All of them are attacking it at a slightly different angle, but really are challenging the same issue. That Parliament and the President failed to enact Constitutional Amendment number 3 in terms of the Constitution, abiding by the strict requirements of the Constitution. So now, what exactly is a referendum? A lot of people have been confused between the parliamentary public hearings and the referendum. So they are two completely different things, different processes. The public hearing is where members of Parliament listen to what the people think. A referendum is where the people themselves make a decision and vote, as I did a moment ago, on whether we approve what Parliament would have enacted. So the referendum happens after the parliamentary process. It was meant to happen, or it is meant to happen, within 3 months of Parliament passing the bill. The easiest way to think of it is like this. A referendum looks almost exactly like an election. So you would still go to a polling station, you would still receive a ballot paper, and you would still vote by secret ballot. But instead of your ballot paper having a list of candidates on it, it would have a question, something a little bit like this, and then you would be voting yes or no on that question. Zimbabwe has had 2 major constitutional referendums in its recent history. So the first was in 2000, when the government had proposed a new constitution and the people voted no, and the draft constitution was rejected. The second was in 2013, where Zimbabwe adopted our current constitution, and on that occasion more than 94% of voters approved the constitution that we have today. And this is why several of these constitutional court cases argue that it should have been the people, not Parliament alone, who decided whether Constitutional Amendment number 3 should become part of our law, given how extensive the changes and fundamental the changes are to our Constitution. With all of these court cases, what happens next? Well, at the moment, all of these constitutional court applications have been filed, and the government has 21 days to file their opposing papers. So for most of the applications, that period of time has not yet expired. Once the government has responded, the applicants will have an opportunity to file their answering affidavits addressing any new issues raised in the government's response. After that, both sides, the lawyers will then file what we call heads of argument. So these are detailed written legal submissions explaining why each side believes they should win. And only once all of these documents have been filed, then the Constitutional Court will allocate a date for those cases to be argued, and then the hearing will happen, and determination on those issues will happen after that. So although the cases have begun, the court process is still in its early stages. And as I said in my previous video, the courts are only one of the 5 arenas in which this struggle will be fought. Important work continues in our communities. It continues in winning hearts and minds. It continues through peaceful civic action. And for many of us, it will continue through prayer and in the spiritual struggle. But the courts do have a vital constitutional role. They are now being asked to answer one of the most important constitutional questions Zimbabwe has faced since 2013. Was Constitutional Amendment number 3 enacted in accordance with the Constitution? And as these cases develop, I'll be continuing to bring you updates on what is going on, so that you can follow exactly what is happening and why it matters. All of us need to remember that we all have a role in defending and restoring our Constitution, and in striving for a Zimbabwe in which all of us have a say, and in which we have a future where all of us are able to participate and play a role in the shaping of the future of our nation. Thank you.